Happy Monday and welcome back to this channel. My name is Mandy Magnan. I'm an actress, writer, producer, and director in Toronto, a movie reviewer, pop culture, and your YouTube commentator for everything. It ends with never. Well, my oh my, it's going to be a juicy one. I just got off the conference call that was scheduled between Jones and Wayfair with Judge Lyman. We're going to go over that. Stephanie motherfucking Jones filed her response to Jen Abel. We're going to talk about that. Then there's a couple of other documents that are floating around, and there's like a real battle right now between all parties, it seems like. So grab your emotional support lip gloss. That's what we're going to be talking about in this video. You are in frame with Mandy Magnan. I think Stephanie motherfucking Jones is a little scared by her little response to Jen Abel, but we're going to save that to the very end. What we're going to go over right away is the judge's conference call. So what they're trying to do is Stephanie motherfucking Jones and her lawyer have served a subpoena on a non-party Catherine Case, even though Jones keeps calling her a third party. Very strange, but the cutoff for subpoenas for any non-party was August 15th, with then a motion to compel, I think, on August 22nd. Well, Jones is trying to get Catherine Case. She served her subpoena very late in the game. The deadline was August. They've been going back and forth, and then, of course, Blake Lively just shows up and is like, I'm supporting Stephanie Jones. Yeah, no duh, girl. What are you even doing here? So there's a whole bunch of stuff about that, okay? And then the judge, he seems to be for once on the Wayfair side about this, but he didn't make a ruling yet. That is still to come. Today they were just kind of going back and forth as to whether he should deny or not this very late subpoena. And now, just before we get into the notes of the conference call, because I took very detailed notes, if anyone tells you these calls are boring, not for me. I love it. I'm like, what's good? What's going on? What's popping? You know what I'm saying? Kevin Fritz did reply to Blake Lively. So for some reason, okay, Stephanie Jones serves a subpoena to Catherine Case way late in the game. Then, of course, Case objects because it's so overbreadth. I mean, the things that they're wanting, which we will get into, are wild, of course, like any of the subpoenas that they've been serving. So Case had some objections. She told them, like, I have to check with my employer, Nathan, because we signed an agreement, and this might break the confidentiality employment agreement. Then when Wayfair found out, they were like, no, hold the phone. We are going to move to quash this. Then Stephanie Jones was like, no, you can't quash it. And they were like, yeah. So they've been going to the court now to try to get the subpoena either served or quashed. Well, then Blake Lively, who's not even in this case of Jones versus Abel, comes in with a little letter of support for her girlfriend. This is what Kevin Fritz had to say about that. Okay. As counsel for Wayfair Studios, Justin Baldoni, Jamie Heath, Steve Swartz, it ends with us, Melissa Nathan, the agency group, and Jennifer Abel. Collectively, the Wayfair parties. We write in response to the recent letter from plaintiff Blake Lively, submitted in support of Stephanie motherfucking Jones and Jones Works LLC's motion in another case to compel non-party Catherine Case to produce certain documents in compliance with a subpoena. Ms. Lively has filed a robust letter in support of a motion filed by another party in another case, in which she is not a party, to compel compliance with a subpoena that she did not serve. Ms. Lively lacks standing to enforce the subpoena to Ms. Case because she did not serve it. The crew of Ms. Lively's contention is that the documents sought from Ms. Case are needed to discredit Melissa Nathan because, according to Ms. Lively, Ms. Nathan's deposition testimony cannot be reconciled with Ms. Case's deposition testimony. Ms. Lively does not explain how any difference in the testimonial evidence concerning Stephanie Jones leaks or any other website is relevant to Ms. Lively's claims or the defenses thereto. Moreover, the use of discovery to establish credibility and gather information for impeachment is limited, especially when the witness, Miss Case, is a non-party. Ms. Lively further argues that the alleged existence of documents concerning websites or social media posts relating to Stephanie Jones confirms there are documents responsive to Ms. Lively's documents requests that were improperly withheld. Yet Ms. Lively neglects to explain, let alone demonstrate how that is true, fails to attach her own document request, and confusingly cites to a subpoena that she did not serve. The Jones Works motion to compel should be denied for the reasons set forth in the submissions properly filed by Miss Case, as well as the Wayfarer Studios LLC, Justin Baldoni, Melissa Nathan, and Jennifer Abel. Kevin Fritz was the one on the call today for Wayfarer, was there for Jones Works, and then there was a bunch of lawyers there for Blake Lively, but the judge was like, this isn't your case, we're not going to hear from you. Okay, so these are all the notes from the call. There's going to be spelling mistakes and stuff because I didn't go through it. I just was like... It was about a 40-minute conference, and yeah, the judge... he wasn't really liking what Stephanie Jones's lawyer kept saying because, of course, they broke the scheduling order. They didn't file a motion to compel. They just went ahead and served a non-party a subpoena without the court's order. You can tell he was a little bit irritated here, but Kevin Fritz, I will tell you right now, is the man we all think he was because he brings up Tay Swizzy, okay, Taylor Swift, right in the judge's face, like, because if we go back, let's get into it. This is what happened. So yeah, there was Blake Lively had a lawyer there, and then she had 4 lawyers there. Anyway, Kevin Fritz first introduces himself. Jones Works lawyers introduce themselves, and then there's lawyers for Blake Lively, and then there's 4 lawyers there for Blake. And then the judge was like, yeah, this isn't really about you, so let's just get to the Jones Works lawyer. It starts with the Jones Works lawyers who says Miss Case had not interjected. She's ready and willing to produce the documents. They're critical because of the derogatory websites that were created for Stephanie motherfucking Jones. It also shows credibility of key witnesses in the case. Miss Case testified that she drafted the website at the direction of Miss Nathan. Miss Nathan testified to the opposite. As a result of that, both testimonies can't be true. Moreover, Wayfarer's objections should be without merit. And she didn't really go on as to why they're out without merit because the judge kind of cut her off. It was like, sounds like you had the information from Miss Case. You think it's highly critical, but if these documents were so critical, why didn't you ask for them in September? Because Miss Case was one of the first people deposed in early September. She goes on to say that it was only after the depositions that we learned who was responsible for the websites. Miss Nathan and Mr. Wallace's testimony of the websites. We didn't know that they would deny the websites, especially once Miss Case agreed to them. So it was only after Jed Wallace and Melissa Nathan's deposition that we are now asking for more documents. They denied everything altogether, which is why we had to go back to Miss Case after the testimony from Wallace and Nathan. We didn't know that they would be testifying the way that they did on September 30th and October 10th and denying creating any smear website, let alone the Stephanie Jones website. The judge says, okay, well, trial subpoena, why not another kind of subpoena? So I guess there's a trial subpoena they could have done instead, or they could have went to the court and filed a motion to compel. And then they go on to say, because we're asking for extra documents that we're seeking in connection with the website, the Jones parties don't have a trial date or summary judgment in this trial yet. So there is still lots of time for us to still get all the information that we need while they are fresh and available. And it would be a huge disservice and super prejudicial to Jones if you deny this. The judge says, you disputed the right question, but what's the cause to allow this? What cause do you have of allowing this to go through? And she said, well, a cause is not necessary here because the subpoena has already been accepted by Miss Case. The judge said, do you have authority absent prejudice to establish good cause? She says, I have ample authority to meet all good cause standards here. The Wayfarer parties point to diligence. In fact, they point to Miss Case document discovery in July, and we should have followed up. But that's not correct. We had to wait for Wallace and Nathan's deposition. We had no idea that they would lie under oath. They're basically really saying that Nathan and Wallace were both lying. Like, that's pretty much the theme of this phone call from the Jones parties. Something I'm still not getting from the judge. Miss Case is relevant to this case, and you didn't know Wallace and Nathan would testify that way. If Miss Case's testimony is so relevant, then wouldn't her documents be relevant? So you should have got them in discovery. The lawyer says she keeps giving the same answer. Oh, I said that. She just keeps giving the same answer over and over about how they had to wait for Mr. Wallace and Miss Nathan to admit to the websites, and they really thought that they were going to admit to the websites in their depositions. So that's why they waited to get the documents. She also goes on to blame the Wayfair people a lot of times, that the Wayfair had the subpoena as of August 17th, and it wasn't until the very last hour that they objected. Therefore, you should deny the motion to quash because they waited so long to object to it. There's no question that Baldoni, Wayfair, and Miss Abel need these documents. And according to Miss Nathan's own testimony, she should have no interest here because she didn't do it. She didn't do the website. So basically, why do the Wayfair people care whether or not Miss Case gives us these documents? And then the judge pretty much tells her that, like, yo, if all of a sudden, he doesn't say yo, of course, but he says, if all of a sudden that you wanted to subpoena and get extra documents, you have the ability to come to me and ask. Then the Jones Works lawyer is kind of like, is a little bit flustered, I think, but then she starts like stumbling a little bit and then catches it and says, I would have submitted motions to compel, but these are very unique circumstances. I'm not saying scheduling orders shouldn't be followed. It's just very limited documents that we request. They're important. Then she just like repeats again that there's no trial date, the depositions, Melissa Nathan's lying, et cetera, et cetera. And there's absolutely no burden on Wayfair. There's no cost. There's no summary judgment. What possible prejudice could it be for Wayfair? And what exactly are these documents? It's not a fishing expedition. These documents could be critical to the case, and it's highly unfair and problematic if you deny it. Then the judge said, when did you first reach out? She says October 15th. Then it's Kevin Fritz's turn for Wayfair. The first place to start is this subpoena is undoubtedly untimely. The due date from your honor was August 15th. Motion to compel was August 22nd. Then he says, it's no short of an imagination here that every counsel in this case knows how to file motions to compel based on how many motions have been filed. There's no shortages of motions to compel, and that was before depositions. So if these were so critical, they should have been requested before the depositions. If you look at the letter, Miss Case did object to the subpoena. Then Mr. Fritz goes on to say that the lawyer is saying that they had to wait for Miss Nathan's deposition in order to get these documents, but Miss Nathan has stuck to her story, girl. Like, what? She even denied the smear campaign back in March. So she just said the same thing that you already knew. They wouldn't have waited to schedule her deposition if it was so critical to Jones. Then he says, Judge, Your Honor, look at the subpoena. It asks for a wide range of documents. October 4th, Miss Case produced all of the documents that were already asked for, and now there's another subpoena for even more documents. And these documents that bring us here today are just an overbreadth of documents. They're asking for this is what got crazy because I didn't really know exactly what they were asking for, okay? They're asking for any text messages, emails, messaging, anything between Brian Friedman, okay, Melissa Nathan, Jennifer Abel, and Wayfair, any post, any comment, anything about to do with any social media posting in the last year. Anything to do with social media posting. These people work in PR. Do you know how many text messages they have probably about social media posts? That's what the subpoena is. That's cuckoo bananas. Then Kevin Fritz goes on to say, nowhere in the motion has Jones even explained why any of this is relevant to the claims. They're literally asking for any posts of anything in the last year. The judge says, well, with no summary judgment or trial date, I don't see any prejudice. Then Kevin Fritz brings up Taylor Swift, and he says, Your Honor, if you remember only a couple months ago, there was a deposition that we were trying to get scheduled for, a very important deposition for someone who's a very famous singer, and we just asked for a couple weeks. That deposition was shut down without any prejudice to Miss Lively and no finding of why it could be conducted earlier or later. And now there's nothing Jones is showing for more documents either. And denying it would be consistent with prior orders to this case, Your Honor. Imagine if we, the Wayfair people, started serving subpoenas all over again. Subpoenas for documents, subpoenas for this, and then we were the ones doing it. Imagine how many motions would be filed. Remember, Jones didn't ask for a rescheduling in the case management. She broke the order, and that's not how it works. Then the judge was kind of asking him, well, she kind of mentioned something about Wayfair still producing documents, so why can't, she get these documents? And Kevin Fritz was like, if they want more documents, they surely know how to file motions to compel. The judge was like, okay, well, with respect to whether Jones is seeking is properly the subject or if it's a trial subpoena for impeachment purposes, Kevin Fritz says, if there is any reason to obtain these documents in discovery, which there were, allowing this type of discovery to proceed now will allow even more subpoenas to be served. Jones is saying that Miss Case is standing there waiting to turn over documents, and that's not the case at all. Then the judge turns to Miss Case's lawyers and he says, we're ready to abide by whatever the judge decides, but we do want to note that we did not withhold any documents in production. Then Jones's lawyer comes in and says, Mr. Fritz spoke a lot about the August 15th order that was set, but we didn't have any depositions before then, so how are we supposed to know what we needed? He also spent a lot of time on Melissa Nathan's denial in March, but we didn't know that once Kay said what she was going to say, that Nathan would then lie again and deny it. It was all about her testimony and that she is denying all smear websites. How are we supposed to know that she was going to say the same thing? And we didn't know she would deny everything again. Then she goes on to blame Wayfair again, that they didn't meet the deadlines either. And then she brings up the spoliation, which I think was not good for her because the spoliation is in actually the Blake Lively and Wayfair case, not in this case. So I think this was really bad for her because it got nipped real quick in the butt by Kevin Fritz. But she goes on to bring up the spoliation and how if they don't get these documents, it's just going to prove even more spoliation. There are spoliations in this case already, documents that we're asking for we didn't get, and that they've already filed a motion for spoliation sanctions. Then Judge Lyman cuts her off again and was like, when the spoliation motion was filed a while ago though, wasn't it? Like when did you file that? Because wasn't that way before even doing the depositions? And then Jones, his lawyer, says, we don't have that date of spoliation, but spoliation is an issue, but we don't have the date when we filed on us. And again, we don't have a trial date or summary judgment date, so you should just allow this. The judge said, did Case testify at the beginning of September? You could have then went to Wayfair when you wanted these documents in September. Then if they didn't answer you, you could have filed a motion to compel then to the Wayfair parties for what you seek now, which completely makes sense. I mean, it's the end of November. People, get it together. Then Jones goes on to say that they would have asked them for additional documents when they needed to. However, in light of the spoliation and not getting what they need from Wayfair, that they're concerned based on that spoliation, that a bunch of these documents would be missing too and they wouldn't be given up. And where Miss Case is now ready and Miss Nathan denies it. And then Kevin Fritz just snips it right in the butt right away with the spoliation. And he says, Jones filed that in the other case. It's not even filed in this case. And it had nothing to do with these so-called smear websites. It had to do with signal messages that have nothing to do with this particular subpoena. So that whole argument is out the window. Pretty much, he says that. I mean, I paraphrased. Anyway, so the judge just basically dismisses everyone after that. He basically just says, thanks so much. I'm going to make my ruling shortly, and thanked everyone for their time. And then that was it. It was a wrap on the conference call. But Kevin Fritz came in good. I mean, the fact with the Taylor Swift thing, yes, I think I said that too like a couple days ago, which is crazy. But anyway, I hope that this is denied because like Stephanie motherfucking Jones, it's November, girl. What is you doing? August was way back playback. You know, I know I'm still wearing tank tops, but it's cold out there right now. It's cold. You were supposed to do it in the sunny days. You know what I mean? It's a little bit too late. And I don't know if her argument with Nathan is going to hold up, because Nathan has stuck to the same story over and over and over. I mean, she's never wavered. She had nothing to do with the Stephanie Jones leak. She's been saying that since March. So you can't now say, oh, well, she said the same thing in her deposition. I don't know. It didn't really sound like the judge was buying it, and he sounded a little bit irritated, honestly, with Jones. And Kevin Fritz put up a good argument. We'll see what happens now. I don't know how fast he'll rule, but as soon as it's ruled, I'll let you know. And I just hope that for once, Wayfair wins this thing, because it doesn't make no sense, okay? If they wanted the documents, they should have asked for the friggin' documents. I don't even care what's in them at this point, but it's just too late. Like, how is there rules for one and not the other? You know, he's denied Wayfair way too much in this case to keep allowing these people to bulldoze their way through the same court case the way that they've bulldozed everyone in their whole lives. No, thank you. Kevin Fritz has also come back in the courts arguing with Blake Lively over her RFAs, which is requests for admission. She has sent them 557 RFAs, but even more than that, for each RFA, now they're saying there's actually way more additional information that they need to approve within that one RFA. So there's thousands and thousands of things that she sent them, and she did them all as a group and with Bates numbers only. So in order for them to even go to one RFA, then they have to go to each person, and it's just taking so much time, and they can't authenticate some of the stuff because it's like things that were written in the mainstream media and journalists and stuff. So they have no way to authenticate that. Anyway, they're just saying, please deny Blake Lively's motion to try to get all her RFAs authenticated and approved for trial, because that's madness. And they are actively trying to work with Blake Lively's lawyers to, you know, do it together and have it seamlessly ready for trial. But they also said there's no way that Blake Lively's counsel even wants to introduce these many RFAs in trial. It doesn't make sense. So basically, they're just trying to waste everyone's time. And so Kevin Fritz is like, just deny it, which is kind of crazy, because now Blake Lively's asked preclusion of the Wayfair parties for the entire smear campaign and the signal messages. So she's missing 38 signal messages from August to December of 2024. And now she wants the judge to preclude any Wayfair defendant from testifying about the contents of those signal messages. So Blake Lively, in her head, wants the judge to allow her and her lawyers to say whatever they want about the contents of these signal messages, whatever they want, that these signal messages mean the smear campaign, and Blake Lively can say whatever she wants about the smear campaign, and the Wayfair people cannot deny it. Nuts. She's also asked for preclusion of Jamie Heath to be able to speak about the pornographic video that he showed her. That was denied. And now she's asking that every single one of her RFAs, whether authenticated or not by Wayfair, be admitted into the court as authenticated. Girl, that's crazy talk. That is crazy. Do you smell that? Smells of desperation. Because, like, it's showing, okay? It's showing, girl. If you got nothing, just, you know, maybe you should be trying to, solve this case. Put it to bed. Close it up. Wrap it up real quick, because it at this point it's just, what are you doing? Anyway, let's get into Stephanie motherfucking Jones, okay? Because she had until the 21st to reply to Abel, which she did. And it's like, I know you're not serious with this reply, girl. I just know you're not serious. I think that she doesn't want to say too much. She doesn't want to give any real information, because there's real federal criminal charges here that could be applied to Stephanie Jones for what she did. But let's just revisit Jen Abel's counterclaim, and then we'll go into the Jones ones, because something here isn't adding up. And let's just remember these numbers. It's like 94 all the way down to like 101. But basically, in Jen Abel's counterclaim, her newest counterclaim filed on October 31st to Jones Works, she is really saying that they have evidence that Stephanie motherfucking Jones colluded with Blake Lively, okay? It is just what it is. I mean, we all know that that was the case, but now they're saying, well, listen, they were talking for a whole month before the fake lawsuit Vanzan came about. Rather than accept the end of the Wayfair relationship with professionalism and decorum, Jones started threatening to sue, demanding exorbitant payment for work not done, and protesting that she had done an amazing job. Jones stewed in resentment and indignity, unable to bear the loss of another Jones Works client. She set out to take revenge on Abel, Wayfair, Baldoni, and Nathan. Jones disclosed at least some of Abel's private communications to the Lively parties no later than August 21st, 2024. Sloan, Lively's publicist, confirmed as much to Nathan on a phone call that evening. Despite lacking Abel's consent to access, review, or disseminate these communications, Jones and Jonesworks were able to do so without difficulty because with the iPhone in hand, they could bypass the password protection that would otherwise bar their access. On or about August 24th, 2024, Jones took things a step further and attempted to contact Lively directly through a mutual connection. A few days later, Jones again reached out to blank, then connected Jones and Lively directly in advance of the call blank. Reeling from a storm of negative publicity, Lively instructed blank. Lively and Jones spoke by phone approximately a week later. A few days later, Lively followed up with blank. However, it is well known that Jones transmitted the contents of Abel's iPhone to Lively, who in turn disseminated them more widely, including to the New York Times. So this whole thing is like, 94 to 100, I guess we'll say, right? Because it's very important, because when you see the way Jones answered this, plaintiff's answer to Jennifer Abel's second amended counterclaims, right? Then you scroll and it's literally just answering it one by one. The allegations in paragraph are legal conclusions. The allegation in paragraph 8 are legal conclusions. And it keeps going. Like the entire document is just going point by point, denying any involvement. She does, though, say that she admits that Stephanie Jones is married to Jason Hodes, who is a partner at WME. The remaining allegations present a complete and or accurate characterization of the matters purportedly described therein, meaning she used her husband's star status to, gain control over some situations. The Jones parties admit that when Jones Works hired Jennifer Abel, she worked for RNCP-MK. The Jones parties deny that Stephanie Jones poached Jennifer Abel. The Jones parties deny that Stephanie Jones had become embroiled in a dispute with another PR firm for stealing its client using deceptive and unscrupulous means, and deny the allegation regarding Jones's reputation. You can't deny that allegation, girl. It's everywhere. It's everywhere. What do you mean? How are you going to deny it when there's so many people that girl, give me a break. So many of your employees, your ex-clients, everybody knows. Like, that's so bad. But this is basically how she goes back and forth on the entire thing. And she denies pretty much, I'm letting you know, almost everything. Like, the Jones party denied, the Jones party denied, the Jones party denied. The Jones party lacked knowledge or information. The Jones party admit that at the commencement of Abel's employment, Jonesworks provided Abel with a company-issued phone and covered the associated services charges for that device. And that device was the property of Jonesworks. The Jones parties deny that Abel owned the phone number referenced in this paragraph and state that the phone number was owned by her prior employer and merely ported to the Jonesworks plan. How can you deny that that was her phone number before working there, girl? Like, pick a hill to die on. This can't be the one. You know what I'm saying? Anyway, she denies all of that. I mean, pretty much it. And a lot of the things that they have as like exhibits or attachments, she literally just writes the contents of which speak for itself. The contents of which speak for itself when it's to any document that was submitted. The Jones parties deny that Abel performed no work for Jonesworks in a state of New York and that she performed the overwhelming majority of her work within the state of California. The Jones party admit that Abel has worked out of Jonesworks' LA office. So if she worked out of the LA office, then didn't she do most of her work in LA, which is in California. So even that sentence to me doesn't really make any sense. She denies. 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 Look at all of that. She denies every single thing. She denies. She denies. The Jones party submit that on July 10th, 2024, Abel purported to resign during a Zoom call and subsequently sent an email regarding her purported resignation on July 26th. The Jones party admit that Abel suggested a 6-week transition period and communicated her intention to start her own business in the future and deny the remaining allegations. The Jones party deny that Stephanie Jones promised to release Abel's phone number when Abel had first joined JonesWorks. Why would you deny something? Like, you know, she's trying everything she can. So now she's even all the way to the point saying that she never said that Jen Abel could have her phone number if she ever left JonesWorks. Why would anyone then never keep their phone number? Like, Jen Abel could have just went and got her own iPhone then if that's all you really wanted. Like, that's a crazy argument, girl, but okay. Deny, deny, deny. The Jones party admit that Jones received certain of Abel's call and text messages logs. The Jones party deny the remaining allegations. The Jones party deny that this paragraph states a complete and or accurate characterization of the matters purportedly described therein. And what Jones is denying there specifically is that in early August 2024, Jones directed Duran to investigate how to gain access to Abel's text messages and call history on her telephone from JonesWorks' provider, Verizon. Duran was able to obtain Abel's call and text logs for the prior 6 months. Jones instructed Duran to make sure that Abel could not port her phone number away from the JonesWorks plan without JonesWorks permission. By mid-August 2024, Jones had hatched a plan to seize Abel's phone outright. She sent Duran to California on August 19th and set the plan in motion. Now, he has been deposed, you know what I'm saying? So how are you denying something? And then you're in the courts saying that Melissa Nathan's the liar because you have someone else testifying something different when you're literally doing the exact same thing. I mean, wow. These two, Blake Lively and Stephanie motherfucking Jones, I mean, the samesies. I mean, it's wild. The Jones parties admit that on August 21st, 2024, JonesWorks terminated Abel's employment in the presence of JonesWorks counsel and a digital forensic contractor and otherwise deny that paragraph 60 presents a complete and or accurate description of the events purportedly described therein. The Jones parties admit that during the August 21st, 2024 meeting, Abel was asked to provide her company-issued phone and the passcode necessary to access it, as well as other company property, as it is standard practice when employees in possession of company property leave JonesWorks, and that she complied. That is wild. You take the phone and you erase it. You don't take the company phone and go through it and then go to the office and go to Blake Lively and go to all these people and share someone's text messages. It's wild. The fact that she's still arguing this. The Jones parties admit that they have not yet released the phone number on Abel's company phone and deny that Abel has any entitlement to it. What? Are you crazy? Like she's not entitled to the phone number? I mean, now it's a little bit too late. It's been over a year, but like, girl, you're dying on the wrong hill here. Like, blink twice if you need help. You know, it's okay if you turn against Blake Lively, but this is just crazy. Trying to say that she's not entitled to that phone number she had since high school, girl. You know better. The Jones party lack knowledge or information sufficient to form a belief as to the truth or falsity regarding whether Abel's device was logged into all of her accounts, registered to her iCloud, and contained all of her photos, text messages, and emails. The Jones parties deny the remaining allegations. The Jones party admit that JonesWorks engaged a digital forensic contractor to preserve data from the company-issued phone used by Abel. The Jones party deny the remaining allegations. The Jones party admit that certain communications were produced during discovery in this litigation, the contents of which speak for themselves, and that JonesWorks engaged a digital forensic contractor to preserve data from the company-issued phone previously used by Abel. She's saying that communications were produced during discovery in this litigation. What? Okay, we move on. Deny, 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 deny. The Jones Party admit that Jones Works experienced certain losses and was damaged due to the August 15th Business Insider article titled "Who's Afraid of Stephanie Jones?" and the Stephanie Jones Leaks website and social media accounts. The Jones Parties deny the remaining allegations. The Jones Party admit that Jones participated in certain meetings, calls, and written correspondence with representatives of Wayfair and Baldoni, but they deny any other remaining allegations. We're getting the point, deny, deny, deny. The Jones Party admit that Jones objected to the proposed engagement of Nathan and Tag due to Nathan's unethical practices, and that Abel disparaged Nathan and Jones and other individuals. Then they deny. They deny. The Jones Party deny that the allegations in paragraph 88 present a complete and or accurate description of the matters purportedly described herein. And they are denying everything that has to do with Vanzan. And speaking with Lively, apparently, because there's no real answer here. We want to look at somewhere between 90-ish, because 95 is when it kind of started. But they go all the way down to like 100. In turning over these materials to Lively, Jones knew full well how they would be used, with slicing, dicing, cherry picking, massaging, and in some cases, outright alteration. The Lively parties exploited Abel's text messages to great effect. Joining forces with the New York Times, the Lively parties commissioned the hit. However, for different reasons, the Lively parties on one hand and the Jones and Jones Works on the other hand needed to create a veneer of legitimacy. The Lively parties likely anticipated or were told directly that the New York Times would not traffic in stolen communications under these circumstances and needed the color of law. Jones and Jones Works, for their part, wanted to insulate themselves from the legal exposure to Wayfair for breaches of confidentiality. Accordingly, on September 27th, 2024, working hand in glove with Jones and Jones Works, the Lively parties and their counsel at Manat, Phelps & Phillips, LLP, initiated a sham legal proceeding in New York State Court, Vanzan Inc., Does 1 through 10. The sham lawsuit was nothing more than a transparent ploy to obtain subpoena power. The plaintiff, Vanzan, is a corporate entity affiliated with Lively and Reynolds and entirely unrelated to the film or the Wayfair parties. The lawsuit asserted 3 causes of action: breach of contract, breach of implied covenant of good faith and fair dealing, and faithless servant against Doe defendants only. It does not explain how or why Vanzan was unable to identify the proper defendants, which is especially notable in the context of a breach of freaking contract. Instead, Vanzan and Manat implausibly claim not to be privy to the identities of its own contractual counterparts or its own employees, contractors, agents, or representatives. The lawsuit is devoid of specific allegations against anyone, much less Abel, and relies exclusively on boilerplate legal jargon. Notably, Vanzan never requested the assignment of a judge, substituted the Doe defendants for named parties, or served the complaint to any defendant. The only docket entries are the complaint and a notice of dismissal filed on December 19th, the day before Blake Lively filed her CRD complaint against the Wayfair parties. The same day the lawsuit was filed, on September 27th, Jones warned a departing employee not to work for Abel because her business wouldn't be around much longer. And it continues. What does she have to say about this? It's all the way from, 97 to 106. 96 to 107. Here we go. Wait for it. This is what Stephanie motherfucking Jones thinks about Vanzan. The Jones parties admit that Jones sought payment from Wayfair, to which she was contractually entitled, and deny the remaining allegations. The Jones parties deny. The Jones party deny. Paragraph 103 purports to summarize a docket, the contents of which speak for itself. That's the Vanzan docket. The Jones party deny the remaining allegations. The Jones party deny. The Jones parties lack sufficient knowledge or information to form a belief as to the truth of the allegations contained in this paragraph regarding Wayfair or Baldoni, and therefore deny them. Then they deny. You know what's so funny? I used to date this crazy abusive narcissist when I was in my early 20s, and it was real bad. But anyway, he used to tell me all the time, if anyone ever asks you something and, you don't want to tell them the truth or whatever, don't create a lie, don't do anything, just deny. Triple D, that's what he used to call it. His second set of triple Ds, obviously we know what the first one is, and then his other ones were deny, deny, deny. And he's like, then, what can they do? You just say no, you just deny, which is, I guess, the triple D that Stephanie motherfucking Jones is going for. Then we get to the causes of action, okay? And you would think that after all of this, because usually what's happened in these cases is that you get the answers and then they come back with their claim. She didn't come back with nothing. There was nothing else after this, okay? But then she goes through all of the causes of action, and whenever she can't answer anything, she just says, these are conclusionary, and if we do need to respond, we deny. We deny. Then, but there are a couple of good ones here that I want to point out that I'm just like, you can't be serious, but basically it's all the same answer for everything. The allegations in paragraph bleep are legal conclusions and therefore no response is required. To the extent a response is required, the Jones party deny these allegations. That's every single one. Now, when it comes to affirmative and other defenses, by alleging the following affirmative and other defenses, the Jones parties are not in any way agreeing or conceding that they have the burden of proof or burden of persuasion on any of these issues. As separate and distinct defenses to Abel's second amended counterclaims and each purported cause of action contained therein, the Jones parties allege as follows. Then they basically just say the same thing. That Jennifer Abel has a lack to standing it. She's waived her claims. This is interesting. In the fifth defense, it says the second amended counterclaims and each claim alleged therein is barred as Abel acted and continues to act with unclean hands. So, and continues to act. Oh, girl, please. The sixth defense, the second amended counterclaim and each claim alleged therein is barred as Abel has not been damaged in any way or at all as a result of any alleged acts or omissions on the Jones parties. She's saying that whatever Jennifer Abel has claimed, Vanzan, walking her out, stealing her phone number, taking all of her shit from her phone and giving them to Lively, that still, even if whatever Jennifer Abel alleged, she's not been damaged in any way. So it is what it is. Girl, Stephanie motherfucking Jones, is you okay, ho? I mean, I ask you that a lot, but like, what? Of course, she's been damaged. What? Because of you. All roads lead back to Stephanie motherfucking Jones. Yes, it does. Because when you got that Vanzan fake ass lawsuit from Lively, you should have sent it to the Wayfair people, baby girl. And you didn't. Okay. And now you and Lively are wanting signal messages from that time. If you wanted them to preserve any messages from August, guess what? You should have gave them the subpoena, babes. Don't play with me. Seventh defense, the second amended counterclaims and each claim alleged therein is barred as Abel has failed to undertake reasonable measures to mitigate the damages she claims to have incurred. Any recovery by Abel must be diminished to the extent that any alleged damages could have been avoided if such measures had been undertaken. Abel didn't know that you were going to take all of her phone and give it to Lively and then comply with a fake subpoena that you and Lively coordinated all together. How could she have taken reasonable steps to mitigate it? We got to be serious here with these answers, And the last one that I found interesting was the Jones parties are informed and believe and on the basis allege that Abel could be unjustly enriched if recovery were to be had on these second amended counterclaims. Justice for Abel. The damages and injuries, if any, suffered by Abel were directly and proximately caused solely by the acts or omissions of individuals or entities other than the Jones parties. Who else? What other person could you think of? Your bestie, Blake Lively? Okay. Abel's alleged damages are too speculative to permit recovery. Yeah, let's just No, there's no actual evidence or proof, so let's just toss it out. What a weak ass argument. At all relevant times, Abel consented to or authorized the Jones party's alleged conduct, including any access to devices, accounts, or data, and the management of the phone number at issue. I'm just going to leave that one right there for you to ponder on. Abel lacks any ownership or possessory interest in the phone number or other property alleged to have been converted, and therefore cannot sustain a conversion claim. Abel's promissory fraud claim is barred because she did not and could not reasonably rely on any alleged promise, and because the Jones party acted in good faith and without intent to fraud. I can't believe it. The Jones party reserved the right to assert additional defenses in the event that discovery indicates they would be appropriate. Then her prayer for relief, Stephanie motherfucking Jones. I mean, the gusto, the balls to even ask for this after such a weak argument back is kind of crazy. She says the second amended counterclaims should be dismissed with prejudice, and Abel takes nothing. The judgment be entered in favor of the Jones party and against Abel. The cost of suit for attorney fees incurred in this action, and for such other and further relief as the court may deem just and proper. And that's it. No arguments, no rebuttal. No, just that. Just deny. But the thing is Abel has evidence because it actually came from people's depositions. Lively, Duran, specifically, that Jones and Lively were colluding for a month before Vanzan. Case closed. It's a wrap. How much longer are you going to deny? And the absolute crazy hypocrisy of it all is that Jones is denying Vanzan and working with Blake when there's evidence, and then going to the courts and saying Melissa Nathan's been lying since March. Y'all are just lying. Everyone's like, I don't know what's going on. Get Wafer the frig out of here and get Jen Abel the frig out of here and away from these awful people. Stephanie motherfucking Jones. Karma is a real bitch, and it's coming for you, girl. It's coming, because I think this is just the beginning of the end for you. Okay? The way you've been treating these people. No. But anyway, that's it for today. I'm still working on the exhibits. There's a lot going on, so I'm still going to get you tons of information this week. And when the judge comes back for a ruling on the case, subpoena, I will definitely let you know. And if anything else happens, of course, I'm your girl. I'm going to tell you, okay? I hope you're having a really great day and had a really good weekend. I know it's Monday, so some people get the blues, but I love Mondays because I'm like, oh, it's a fresh week. We get to go. Let's set the tone. So I love them, but I hope, maybe I could rub some of this Monday love on you and hope that your day just gets a little bit better. I hope tonight you're able to love yourself a little bit more, take a couple of minutes out for you, cherish yourself, take deep breaths, and really, 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 truly be grateful to being here, I love you so much, and I can't wait to talk to you again. I'll be back. Anyway, okay, bye. What the frick?